Good afternoon and good evening, everyone. We're going to wait a few minutes. I see a bunch of attendees signing on now, but welcome to AIIC Group's webinar with special guest Stephen Pazan. We'll be joining here and starting in just a few moments. Um, there will be, like all our webinars, have a quick introduction on AIIC Group as the regional center and the NCE. Of course, most importantly, an introduction of our special guest here today and his background. There is an open question and answer dialogue box for anyone to pose any specific questions that they have. Because there's a large attendance group of over 100 plus attendees. If I don't get to a specific question, just due to sake of time, please do feel free to WhatsApp me or email me, and we can get those answers either by myself or through Steve or anyone if I can't get to all questions just because of the size of the group that is attending today. Just give it about 2 more minutes as I see the number increasing quite a bit. All right, I think we can start now. We got quite a few on here already, and I think it's fair for us not to follow IST. So for those listening, I'm sure some of you know what that is. Anyhow, welcome to AIIC Group's webinar once again. This is our monthly online webinar. Specific topic is inside the EB-5 adjudication room with special guest Steve Pazan, hosted by Kevin, Aaron, and myself from AIIC Group. We'll give a little bit of background on AIIC, and then we'll dig right into some of the specific questions that we have. So AIIC Group is a regional center, multiple regional centers, and NCE. Our focus, of course, is number one, get EB-5 investors their green cards, how to get their money, number two, how to get their money back, hard-earned money back as quickly and safely as possible under legal EB-5 rules and regulations. We focus on risk awareness, compliance-driven, and of course, investor focus. We are a mid-sized regional center and NCE out there with over 21 successful EB-5 projects. Helped over 1,600 families from all over the world, China, India, Vietnam, Brazil, Mexico, get their green cards and safely get their capital back as well. Also through the various partners, we're responsible for over 230 regional centers out there as well. We have some great active I-956F approved projects, including our Aspen-based hotel, which if anyone's interested about, they can ping me later, as well as an upcoming infrastructure project that we'll announce here shortly. Again, just a little bit about the partners. We're very politically involved. That's how a lot of us got into EB-5 on both sides of the spectrum. So it doesn't matter whether Democrat or Republican, but working in the EB-5 space and working with the government, both current administration and previous administration, from Obama to Bush to Trump, all the way in India with Prime Minister Modi ji as well. So a little bit about the background of AIIC Partners, and then we're going to get into the crux of it here. So Kevin Wright, founder of Wright Johnson and Wright Goforth Capital with Aaron Goforth. Both of them do the EB-5 business plans and economic analysis and reports not only for our projects but also for many other projects and regional centers out there as well. They sold their company, a portion of it, to Baker Tilly, and world famous economists out there have written many books on EB-5. Congressman Aaron Schock, a partner of ours that was the chief sponsor of reauthorizing EB-5 law in U.S. Congress back in the day. He's the guy that actually taught me quite a bit and introduced me to Kevin and Aaron quite some time ago. Again, we've been doing this for over 15 years myself personally. And I myself, besides AIC Group, am the CEO of ABG Group and chairman of the Republican Hindu Coalition with about 100,000 Indian American members out there. And great, our special guest, Steve. First off, welcome, Steve. I appreciate you being here today.
Thank you. Thank you.
A little bit about Steve. He's a former consular processing IPO officer and adjudicator at the USCIS. He's done over 500 I-526 individual petitions, a lot of focus on SOF, which is source of funds, and we're going to go through some of these questions related to source of funds. He's evaluated and approved as well as denied multiple regional center applications, what they call the I-924s for EB-5 projects. We're going to talk a little bit about that. Experience with EB-5 project issues and how to overcome those, and what all from the USCIS perspective, why those issues were there. And also, today's webinar is about also, let's get an inside perspective of from someone who's issued hundreds of RFEs, NOIDs, outright denials, right? Even working on an appeal decision. So really knowing the ins and outs of, what happens from the inside perspective at the USCIS. So once again, Steve, really appreciate you being here today and joining AIC Group. We already have some questions already posing from the participants, but let me go ahead and lead with some of the first few questions, and then we'll kind of
Let me
make this
stop.
into.
Before you do that, Vikram, let me just add one thing that we don't have on the truncated bio here.
Sure.
People might be interested to know that in addition to what you see here, I was also a consular officer with the Department of State. So I actually issued visas over the consular table in Ukraine, in Colombia, in Chile, and in Poland. So I think I might, I have a perspective on this entire process from the very beginning, when the person comes in and signs up with a project, to the very end when they walk out of the consular section and wherever they live with a visa in their hand.
Awesome. Well, appreciate that additional insight. And by the way, I'll also be sharing Steve's contact information at the end of the entire presentation as well. He does have Pazan Consulting services and can give a lot of great insight to investors out there, is great to work with. Steve, as a first question, working as a former USCIS IPO officer, has decided on over 500 I-526C petitions out there. From an SOF perspective, source of funds, looking at investor applications, what were some of the criteria points that you'd kind of look at particularly?
As you can imagine, as anybody can imagine, there are certain non-negotiable points. So let's not talk about them too much, right? Here we're talking about things like, did you sign the application? This sort of thing. But let's put those aside, because I think what you're really asking me is, what was the thing in a source of funds presentation that made somebody's presentation credible and approvable, right?
That's
And
correct.
and the answer to that question is a cohesive story. So, a little bit of additional background about me that'll help people, I think, understand what I'm trying to say is that before I started working for the government, I began as a litigation attorney. And as a litigation attorney, I was trained very early on as a prosecuting attorney in New York to create a narrative for the case. What is the story of the case? What is this case about? And that's really the first thing that you would look for when you look at a source of funds presentation from somebody. What is the story here? What is this guy, this woman, what is he about? And if it all holds together and it makes sense from the perspective of a life story, a narrative, then that credibility will kind of carry the entire presentation through an eventual approval. So that's the first thing you look at. Does it make sense? Would a person with that particular job, with that particular education, would that person be likely to be able to get $800,000 together and invest in an EB-5 project? Would that person with that education be married to that guy or that woman? How does it, so even things as simple as that sort of lend credibility to an applicant's presentation. So the first thing you got to do is what's the story? And in fact, USCIS uses an adjudicator worksheet, and the adjudicator worksheet has a box at the top, and it asks the adjudicator to summarize the the source of funds. So if you can imagine, it's almost like you're a prosecuting attorney and you're trying to convince a jury, but the jury is a jury of one, the jury which is the adjudicator. And when you stand up in front of the jury before you try the case, you say, ladies and gentlemen, I want to tell you what this case is about. This case is about a hard-working man who inherited a family business and enhanced that business to the point that he was able to buy two vacant properties, and on the outskirts of Delhi, which were ultimately improved. Homes were built on them, and they were sold at a profit. That's what this case is about. So that's the kind of thing that you try to do.
Okay. But as a follow-up, let's talk about a little bit more of the difficult cases out there. So, um, with respect to when you would be filing, when you're evaluating a petitioner's I-526C, and you need to issue some sort of RFE, request for evidence, or an NOID. Walk us through the process there. Is there certain approvals needed? What is it that you're looking for? If something is not sufficient and hence why you want an RFE, perhaps you can elaborate a little bit on that, please.
Yeah, it's a really good question because it explains why there's a lot of noise in RFEs and NOIDs. And by that, I mean, when I read them and when I issued them, there were many things in RFEs that the adjudicator really wasn't all that interested in. But the problem is that for economy's sake, adjudicators were told to make sure that you ask for everything that you possibly could ask for on that particular case in the RFE and or the NOID, because you don't want to have to issue another one. Folks may not realize it, but there's no rule that constrains an adjudicator to only issue one RFE in a case. Theoretically, the RFE could be followed up by another RFE and another RFE after that. But internally, they don't like to do that. So what'll happen is often, you'll see something where, I don't know, maybe there's a little bit of sketchy information with regard to the trail of certain part of money through a bank account. But in that same RFE that asks for more bank records to establish that transaction, that path of funds in that transaction, they may very well ask for additional tax documents. If the adjudicator had everything that they need for the bank transaction, they might not really be all that concerned with the tax documents. So on the one hand, it's important to look at these RFEs and NOIDs to find out what it is that you're really lacking, so you can see what the adjudicator really cares about. Now, from a mechanical perspective, like in the office, if you're an experienced adjudicator, you do not need approval from anybody to issue an RFE. So when a 526E comes in, it's looked at by one person alone. For the most part, when I first started working at the investor program office, it was totally random. And I might, call up 10 files to work on. And you get these things, and they could be in 10 different projects. They later went to an adjudicator dedicated to a project kind of model where, they thought it would be more efficient because if you got 10 files that related to one project, you already knew, what you were looking at. Less important now that the adjudicators are not looking at project issues because of the new RIA and the like. But I'm assuming that that's still how they do things there, right? So anyway, so it goes to one adjudicator. That adjudicator looks at it, decides what he or she doesn't like about it, and issues the RFE. Now, if it's NOID time, let's say the response comes, and they read the response and they're not happy about it, and they decide to issue a NOID or, God forbid, a denial, then they need supervisory concurrence. So they have to prepare it. Then this will be experienced by the investor in the form of additional delay, right? Because let's say two people in a project get an RFE on or about the same day. They may be penned by the same adjudicator. You won't know. But let's say the two responses come in and then one gets approved and then the other one's delayed. The reason it might be delayed is because they gotta write the memo internally to their supervisor. They gotta have a little meeting with the supervisor. They gotta chase the supervisor down to make sure the supervisor reads it. And then they might have to answer some questions from the supervisor about it. Same thing happens with a denial. So NOIDs and denials generally are looked at by more than one set of eyeballs.
Got it, got it. And in particular, like any sort of red flags though, when you're looking at source of funds, like for example, personal loans, my understanding is okay, but is there what sort of red flags do you think pop up that make you want to issue an RFE or it made you want to issue an RFE, I should say, when you're looking at source of funds in particular?
Well, you look a little deeper. Again, I'll keep hammering this point. You go back to the narrative in the story. So let's say there's a loan, right? So there's a loan against some property or maybe a personal loan, not secured, whatever. So there's a loan. Who's the lender? Why would this lender make a loan to the investor? So if it doesn't make sense, that's a red flag. So if I'm not a commercial lender, right, one would not expect me to make a loan to you unless you and I had some relationship. So if that relationship is not explained, if I got a loan of $200,000 for some random guy, of course the adjudicators, antenna go up. And they're looking all through that source of funds report to find out who this person is. On the other hand, if we make it clear, why would he loan me that money? He's my brother-in-law. He's been very successful. He loves me. That's why he's loaning me the money. It's very simple. And that's actually a little caution to some of our prospective investors. Many people feel, for whatever reason, that they shouldn't display in their I-526E filings or their source of funds reports, they shouldn't display their humanity. They shouldn't display what's really going on, the nuts and bolts of their life. But those nuts and bolts, those interpersonal relationships are what make these presentations credible. I'll give you an example. I recently did a direct investment project, right? And in the direct investment project, I put together the source of funds report that basically laid out the fact that all of the prospective customers for the new commercial enterprise were friends, relations, connected, it was, to the principal investor. So while these people weren't the source of funds, and while these people didn't necessarily have anything specific to do with the requirements of the EB-5 program, right? they lent credibility to the presentation and the concept that this business was going to be successful. And then I argue in it, I say in the source of funds report that from the perspective of deciding whether this business is going to float or not, or whether it's going to sink, there are a lot of people who may not be financially invested in this, but they're invested from the perspective of their fraternal relationship and family relationship to the investor. He's got people rooting for him, helping him. He's got people, you know. So again, it's always about the story. And when you ask for red flags, you say, is there something, if there's something missing, what would it be that could be missing that could tank or defeat a presentation, right? This is ultimately, in some ways, your question.
Mhm.
You read all the RFEs today, if you read the NOIDs today, you'll see that more than ever before, they're asking for 7 years of bank records. So USCIS believes that the Reform and Integrity Act actually enhanced the obligation to produce, I'm sorry, not bank records, tax records, that the RIA actually enhanced the requirement to produce tax records. Maybe it did. I disagree with that. I don't think that the law, because it says as applicable. So if it's not applicable, why do you have to produce tax records, right? I mean, if I'm 22 years old and I win the lottery and I win $20 million in the lottery, what difference does it make whether I give you 7 years of my tax records? You know perfectly well where I got the money from, and there's no question, right? So, but you'll see that in there. But yet, on the other hand, you guys are aware that USCIS has approved hundreds of cases where people haven't produced 7 years of tax records. So, it's not right to say that it's an absolute requirement, although it kind of is in the regulations, but it's not what will be the make or break for your presentation.
Got
So
it.
I didn't answer your question, and that I think is the answer to your question.
I got
Basically,
a
yeah.
follow up to that. Uh, like when you were looking at these things, something that used to come up for me a lot was investors would, like they'd have like 90% of the documentation they needed or something, but maybe they were short and they couldn't find specific things. And so they would sign like an attestation that says, hey, I swear that I got this $15,000 from this place, but I don't have the documentation because it was 17 years ago or something like that. Is that something that's like routinely accepted on like I could see where if the person is missing one little piece and they have an attestation, that's fine. But what if they're missing four pieces? Or how did you guys look at that?
Yeah, well, there's no formula for it, but your question is a really good one. And if anybody is inclined to do it, they can look at the recently decided Battinelli case, which involved two brothers, right? And it was a source of funds issue. One Battinelli brother was approved, the other Battinelli brother wasn't approved. And it was a situation just like what you're saying. But the reason why the origin of the loan funds became so important was not because really USCIS didn't believe the Battinelli brother on that particular issue. It's because there were other things that were lacking. So, your point, if there are 10 elements of a source of funds report and 9 of them are really, really strong and one of them's a little weak, USCIS will approve it because there's a kind of a penumbra, right? We could say of legitimacy and credibility from the 9 that are strong that'll overwhelm the one that's not strong. Now, the other thing is that a simple statement, is probative. So it is fair evidence. Not everything has to be in a document. And I have a case right now that actually today I was supposed to receive the last filing from the government. It was a case that came to me. Another lawyer had done it, was denied, and so I filed the judicial review of the agency decision. And in that particular case, we're arguing just these things. We're arguing that they're asking for documents that are 16 years old, that no reasonable person would have had in his or her possession at the time that they filed the thing. and so on. I have another case which went in, and we got an RFE on that one because the attorney that filed it must have dropped the file because all the pages the reason for the RFE was the pages were out of order, really. But in that particular case, the woman was here in the United States, and at the time that the money was transferred to her from China, there was no conception that she was going to apply for an EB-5 visa. In fact, if she had an intention to apply for an EB-5 visa, she would have done it while the investment amount was $500,000 rather than $800,000. So because she didn't receive the money with the expectation of having to prove up a source of funds report, she has no records of how and when this stuff came to her. But her affidavit and the affidavits signed now for then by these people were sufficient that that's not even really an issue in USCIS's RFE on this particular case.
And that brings up a quick going back to your experience here and what we were talking about. Now, you talk about the cases you're currently working on, and I'm assuming that's because nowadays, like that's what you're hired to do is help with difficult source of funds. So, like if
Right.
investors have questions or something, they can hire you to help them.
Oh, yes. Yeah. And file
Okay.
from, I'll file G28 and file petitions for people as well now.
Mhm.
You go, your work expands, and moves out in different directions.
So,
So,
so some of the questions, Steve, around source of funds, and then we'll move on to some other subjects as well, are like loans against property in India, and in particular, from a USCIS perspective, is it okay? Because like many people think because of FEMA regulations, it may not be okay. What are your thoughts behind that?
USCIS I don't know of any cases where USCIS has denied a petition because they said that the loan was secured, by property in India in violation of FEMA. So it never was an issue for me when I worked there. And I don't consider it an issue now. And in fact, when you ask that question, you're suggesting to me, well, Steve, actually just filed one recently where we did this. And so the question is that a violation of FEMA? Well, first of all, I don't know of any, like I said, I don't know that USCIS has ever said that it was. Second, even if it was, was there a fraud? No. Would the individual still be liable on the personal debt? Yes. So I don't know what that changes from a USCIS perspective.
Yeah.
If I try to find some reason to your question, right? If I try to find a reason to worry about it, it might lead me to ask, well, we're told that we need to use a lawful source of funds. If this particular arrangement is a violation of FEMA, does that mean that the source of funds is unlawful? Well, no, because the source of funds was a loan against the property. Both parties agreed there was no fraud, there was no misrepresentation. We've seen this distinction made in some lawsuits now. I think the one case is the Zhang case, I think it was, where there was a money exchanger. And there was some question about the money exchanger and whether the money exchanger was properly documented and the like. But the court ruled, right? The court said, well, the money exchanger can have some wrinkles in it, but he's not the source of funds. He's just a conduit. So he doesn't add to the investment corpus in any way. So if that's the case, then I don't see why that same doctrine wouldn't be extended to this FEMA stuff. It's not, I don't see it as a problem. The day that somebody gives me a horror story and says USCIS is fixed on it and denied a case, then I'll tell you differently. But right now, I
Yeah.
don't see a problem.
No, I think the concern is like, between FEMA and LRS, like India does not allow or doesn't allow, yeah, to take a loan against, let's say, a property in India and, finance that for a US based investment. However, I guess my follow-up question to that is if the bank is willing to do so in India, it's not like you and the USCIS are contacting, India authorities and India government and, verifying all of this lawful. I mean, that's you have if the India bank is willing to do so, and you have an Indian citizenship as well, from your perspective as the USCIS, it's still lawful, correct?
I would think so. And and again, I'm trying to give the question and the concern credence. I mean, as a lawyer, that's what you do. I don't see this on the radar, and then somebody asks you a question, and all of a sudden you go, "Ooh, and maybe I should think about that a little bit." But if you think about it, what would be the purpose of these laws? The purpose of these laws is to restrict capital flow out of India and also to retain ownership of property within India. So my argument would be that if you even think about the law itself, right, as long as the person who ultimately can take title to the property is either an Indian institution or an Indian citizen, then why would India care?
Right, right. Okay, no, that's very good. Um, Here's another question for you. There's some investors out there who may file in the same project at the same time, relatively, with, let's say, a cousin or a friend, and similar source of funds not being the issue, but they may have filed their 526C petitions at the same time, and one got approved, but the other is not, and it's even weeks later. Does that mean automatically the investor should file a writ of mandamus? Is it, why would that be the case? Like, maybe talk a little bit about how the internal dynamics of who's assigned the various investors or projects, or what does it look like inside the USCIS war room, I
Well, when I
should say?
talk about that, you and everyone listening are going to be really disappointed in the United States government and how poorly things work because it's not really that complicated. But start out with the proposition that I will tell you that there were cases I had when I was there where, I'd look at a case and I'd approve a case, and then 3 days later I'd see another case and I'd be reading through that and I'd be like, hey, wait a minute, that sounds a whole lot like the one I did 3 days ago. And so, the worry that I would have as an adjudicator would be like, am I reading the same source of funds that are being attributed to or encumbered by two different investors? So one thing I would do, right, whether I was a filing lawyer or an investor, if I knew my brother or my brother-in-law, or whatever, was filing at the same time, and I knew that a lot of the same material was going to appear in both of the petitions, I would reference them so that the adjudicator knows. Because if you got Smith comes in and Smith puts his source of funds report in and says he got the money from Goforth, and then Wright comes in and Wright says, "Oh, I got the money from Goforth." Well, wait a minute. If you don't explain how Goforth came up with $1.6 million, then you're going to have a hiccup on the other end for number two, because that guy's not going to get adjudicated until the adjudicator can figure out what happened. And he or she may have to call back a case, which is really hard to do, and it takes time. So don't be afraid to let everybody know that it's a family affair, and you can cross-reference the petitions as long as you do it in a way that doesn't that the attorney does it in a way that doesn't give up confidences. You can and should do that. But then internally, what happens is that so at the IPO, right, there are adjudicators who are employed by USCIS, and they are served by contractors, who are contractors with the federal government. And those federal contractors are responsible for physically hauling the files around. So when the file gets to the IPO, they're the ones that put the holes in the top and put the little things on it to put them in 500-page bundles. And so, then each bundle goes into a file jacket with a scanning sticker on the top. And these contractors don't work for the U.S. government. So the adjudicators have no managerial responsibility over those people, although they rely on them to be fed cases. So I'm sitting at my desk, I'm adjudicating cases, and I send a little email and I call down, I say, send me 10 cases for adjudication. Down in the basement, right now, we've all seen what these cases can look like. Some of our clients are filing cases that are 1,000, 1,500 pages long, right? They're big. So down in the basement of the IPO is a big giant room, and it's full of files, and it's full of, they're all gathering dust, cobwebs, and they're in big giant piles, and there's, probably some attempt to organize them, but the adjudicators don't know. And literally, sometimes these guys go down there with a flat, to go get 10 files to bring up to you, the adjudicator. And when they open the door, there's a file on the floor. It's fallen down. It's slipped off the pile, right? So when they pick it up, they put it on the cart. And then they put 9 other ones on the cart. And so sometimes what happens is it's as simple as the fact that they're out of order. And it has no significance whatsoever other than the pure physical issue of collecting and producing files for adjudication. Simple as that. So now there are exceptions, certainly, but I want people to understand sometimes when they're anxious about these kinds of things that not everything USCIS does has any meaning or any significance at all. There's no, we've all seen The Wizard of Oz, there's no magician behind the curtain there. I would say that USCIS's general approach is one of limited competence to do what they're doing. And to their defense, the amount of volume really is incredible. So, maybe the four of us couldn't do a whole lot better, but that's the reality of what we are dealing with.
Makes sense. Makes sense. Here's a question from a potential investor. If you want to change your source of funds in an already filed 526C, we all know that that part is not okay, but is it okay to cancel the initial filing and then file a new one with the changed source of funds?
Yeah, sure.
Um,
Whether or not you're going to retain the priority date depends on a lot of things, but
exactly. That was going to be my follow-up and point is that, yeah, you would cancel it. And well, let me give a follow-up question for that investor. What happens if, I mean, because the process of canceling it, the USCIS officer will see that cancellation before they get the new one. I mean, it's all like you said, it could be two different officers. That's where it could get a little bit mixy. I mean, in general, you generally want to figure out your source of funds in the beginning. But obviously, if things change, right?
yeah, I mean, I would just explain it. That's all. Like, I don't know, we can imagine a case that I don't even know if this would be a material change. I mean, this is the real question is when you're talking about changing stuff, is it a material change that you need to tell USCIS about and that would affect the adjudicator's approval or disapproval of the file from the moment that he gets it? Because some of these things are, minor changes, which are reasonable probably don't even affect this. What are you changing? I don't know. You said it's a partial investment case, and you're going to complete the investment by selling your securities at Charles Schwab three months
Mhm.
later, and then 3 months later, comes along and you decide you like your position at Charles Schwab, so you're not going to do it that way. You're gonna, I don't know, you're gonna take a withdrawal loan against your 401k or your IRA or whatever it is, or however, that's done. I don't know that you even need to let USCIS know about that because I don't think it's a material change.
Got it. Makes sense. All right, let's shift a little bit now. That's from an investor source of funds standpoint. What about from, as an IPO officer and adjudicator, you've filed, you've done several I-956F approvals, or done I-924 approvals for the EB-5 regional centers. Walk us through a little bit about what you look for in an EB-5 project to give the I-956F approval, or for a regional center to qualify to give an I-924 approval, please.
It's a little bit more difficult for the adjudicator because it relies to a much greater extent on an economic analysis. So, because you're talking about the job creation criteria and the econometric models that are used, I'll let Kevin and Aaron probably are better qualified to talk about how those things are put together than I am. But as an adjudicator, a line adjudicator, not an economist. Now, this is done in teams, right? So they'll put together a team of a couple of people who will review a new project, a new 956F or whatever, and that team will include adjudicators as well as economists. And the adjudicators have to stand by, and wait for the economist to do his or her work to determine whether the job creation stuff is correct. And as long as it's not a crazy file, there's no real issue if the jobs are there with regard to the potential success of the project. I didn't see too many files or too many cases where we looked at a project that didn't, of course, when I was there, it wasn't the Reform and Integrity Act. It was still legacy EB-5. But there weren't too many projects ever, I don't think, that we looked at and said, this is a crazy idea, it's never going to work. So, other than making sure the T's are crossed and the I's are dotted and the forms are filled out right and the codes are there, on the applications, and there's not really a whole lot for the adjudicator to do in terms of discretion.
What about like the economists on your teams with respect to, the third party, when a regional center or the NC regional center proposes or submits additional documentation like a Jones Lang LaSalle third party audit of the business plan or HVS?
I think that's
Would
all
the economists
helpful.
use those?
I think that's all helpful from the perspective of credibility. I think it all helps. It doesn't hurt. It's, probably worth the money. But at the end of the day, again, I'm not an economist, but it's this RIMS 2, right? Criteria that really moves the needle.
Makes sense. Makes sense. Okay, let's see. We have some
By the
investor
way,
questions.
by the way, some of the delays, some of the delays that you'll experience waiting for those kinds of approvals, again, there's no significance to them. When you're talking about doing something as a team, the team has to be there in order for the thing to conclude. So if I'm on that team and I'm responsible for ultimately signing off on the approval after the economist does his or her work, and there's been a hurricane, which happened while I was there, and then I am seconded to the, not India FEMA, but America FEMA, and they go out to, work on hurricane relief down in Baton Rouge or something like that. It's not going to get approved until I get back. So sometimes, again, you'll find delays. Those delays have no
That
significance.
Yeah, that brings up an interesting question I have, which is like I get asked all the time, especially with people worried about retrogression at some point and different things. How did you guys look at mandamus requests, right? Does that in any way endanger your application or make people mad, or is it a good idea, or
Yeah, people worry about
what are your
that.
thoughts
And
on
so what I noticed when I was there, and what I tell people now, is that you shouldn't be afraid of that. Now, don't file mandamus when you shouldn't file a mandamus because you're wasting your money and you're wasting your attorney's credibility with the court. But it really doesn't have much to do with USCIS. So let's talk about, let's break down mandamuses a little bit. If it's a 956F, and I had one, I did one, finished one for one of your competitors just a couple of months ago. And there, who knows? But let's take my example from before and say that the adjudicator that's on the team is, I don't know, she went off to have a baby. She's on maternity leave. So they get a mandamus case and they look at it and they say, oh, all right, we're going to have to reassign that to, I don't know, to Vikram. Let him do it. And then Vikram's put on it and he picks it up for the woman that's not there anymore and it gets adjudicated. But, they don't find that to be a very offensive thing. If we then go to we'll go to the vast majority of them, which are 526E or 526 adjudicatory delay mandamus cases, right? what really happens in a mandamus is you file the thing, it gets served, it ends up with a DOJ attorney that's going to handle the file, right, at the U.S. District Court. That DOJ attorney calls up his or her counterpart at IPO, which is a USCIS in-house attorney that does not work at IPO. They have other duties at USCIS, and maybe they only work at IPO once a week. So they're really busy, right? There was a woman there when I was there, and we never saw her, and she was impossible to get a hold of, you know? So anyway, the DOJ attorney will call up the agency attorney, in-house attorney, and say, hey, I got this mandamus filed by this guy Pazan, and can you look into the case and find out what the real story is? So at that point, the agency attorney takes it, goes to IPO, looks in the computer, figures out what adjudicator has the case, if it's been assigned, asks that adjudicator, what's the story? When can I expect this to be done? Can you hurry up, please? Because the DOJ attorney doesn't want to have to defend that mandamus case. Now, supposing it hasn't been assigned, it's still down in the big file room, and it is late, right? Supposing it is late. It should have been. It's that case you were talking about before, for your brother-in-law where yours got approved and his hasn't, and it's late. So then they'll say, well, look, they know where the cases are. So they call it, in there, they call it wanding it in. So there was a file jacket with a UPC code, and they have an electric pen, everybody on the computer, and they just wand it in. When they do that, that tells the system that that adjudicator has that file. So every file number is associated with a physical location or a person that possesses it. So anyway, they say, oh, well, it's downstairs in the big room. And yeah, it probably should have been adjudicated 5 months ago because everything else in that particular project was adjudicated then. So they'll send somebody down there on a sleuthing mission to go find it. And then when they find it, they'll assign it to somebody. Now, meanwhile, you've hired me, I filed the mandamus, and we're waiting our 60 days for the government to file its response to the mandamus. Now, in 80% of these cases, they're going to file that and going to realize that the investor and the investor's lawyer filed the mandamus are correct, that it should have been done. So they get it, and they don't reach out to the lawyer and say, hey, thanks for the mandamus, we're going to do it tomorrow, because they don't want to encourage people. So what they do is they just mysteriously adjudicate it. And I would say 8 out of every 10 times, maybe I'm the brightest, smartest attorney there ever was, because I write such great federal district court complaints for mandamus that they get scared of Steve Pazan and they adjudicate all the cases. Or maybe they just know that if they just adjudicate these things, once we tell them, hey, you forgot about us, right? That's basically a mandamus says you forgot about us. So then they say, oh, you're right. They adjudicate it. And then they know that I'm just going to withdraw the complaint. So 80% of the time, if your mandamus is filed at the appropriate time, like not 2 weeks after you file, not 2 weeks after it's overdue, but I don't know if they push back, they like to look at the processing dates that they put on the website. So if it says right now, I think it says I-526E processing time, 80% of the cases are adjudicated within 16 months. That was what I read today. So if it's 18 months, you can file a mandamus without getting yourself or your attorney in trouble, because it might be they just forgot. But if the 80% processing, metric, is 16 months and it's only been 7 months, don't file. It's not worth your trouble because they might get angry at you then, and then they'll fight you. You don't want them to fight your mandamus. You want them to adjudicate your case. That's what you want.
So when would be a good time or a reasonable time then? Let's say if rural is on average being adjudicated in like 4 to 6 months, and HUA is a little bit longer, due to the different priority processing. Would you say, you definitely don't want to do it
Well,
2
I
or 3
actually,
months in advance? Yeah.
yeah, no. Just to add to that, and so, I look at different things, right? So, same question, but the things that confuse me are like, okay, so if you look at IIUSA data, which is their internal data by their own clients, it's not like public, but they estimate that the average time to get a rural project I-526E adjudication is 8 months, and that a HUA is 11 point something months. However, if you go on LinkedIn or something else, you can see that everybody selling a rural project loves to put up on the screen or on their webpage that their project was approved in 3.9 months for their 526Es, or 4 months, or and you see a wide variety of cases through anecdotal evidence, talking to the attorneys and so forth, that a lot of them really do get approved in 4 to 6 months. Well, the difference between the 8 months, that's the average of all of them, according to IIUSA, and the 4 to 6 months makes a big difference if you're a person that's worried about retrogression. So would you say, like, well, okay, if you made it 4 months, now you have a credible argument that somebody else got it in 4 months, so I should too? Or should it be 6 months? Should we have to wait 8 months? Like, what
Well,
kind of, what do you think?
I was thinking before you asked that question, what I was going to add, because I think it answers your question is, so it depends really on you and why you need it at that time. So, for example, if there's something else going on in your, I don't know, you're on an H-1B and you're going to lose your job and your employer doesn't want to renew. So maybe when you file the complaint, you say, hey, number one, I need them to move on my case on my 526E. And the reason I need them to do that is because in a short period of time, I'm going to be out of status. So not only is there a delay, I acknowledge, Your Honor, that it's not a significant delay compared to most, but it's significant to me and it injures me. Now, you do that in a polite, respectful way. USCIS picks that file up and says, oh, we don't want this guy to get hurt. So rather than fight it, maybe they adjudicate it and you get what you want. So that in my complaints, in my mandamus complaints, I try to make it a little personal. Like, why does this matter to, like, so for example, not in a 526E, but in a 956, the project one that I filed recently, they had emails from 4 different prospective investors that told them, thank you very much, but we can't invest in a project that doesn't have an approval yet. And we've got to move, so we're picking a competitor. So I was able to put that in the complaint and say, look, this delay, here are 4 cases, 4 instances where this regional center, where this project was hurt because they couldn't compete with everyone else because of the delay. So, so I craft my mandamuses for the person that I'm representing.
Mhm. Now,
So,
when cases
so,
are,
so to answer that question, it depends on you. You know what I mean? It depends on your problem. When you come to me, if you're in duress, I'll help you more likely rather than say, hey, you better wait. 2 guys are not in the same position if they're in 2 different situations with regard to when they file.
how are cases picked? Like, from inside the USCIS, like, does it make a difference? The question from an investor, potential investor, is whether there's a separate queue for F-approved projects versus non-F-approved projects. My understanding is obviously a non-F-approved project will a 526C cannot be adjudicated or approved, obviously. So,
Right.
but are there different queues? Are they, looking at, ones who have full funding versus partially funding? Like, how does that all
Well,
work?
well, let's talk about partial funding for a minute, right? But let's lead into it by talking about some of the changes that I think are going on based on RFEs and NOIDs that I see, right? So when I was there was no separate queue for anything. So you just called up the cases, you were assigned to a project, you're doing the I don't know, the Hilton Hotel project, whatever it is, and you call up the files and you work on it, and that's that. But I've noticed over the past couple of months that some of the RFEs are coming in different formats. So it used to be, if you think about it, maybe those of us who've been around this industry for a couple of years, that every RFE had the same heading, the same type, the same text, the same everything. And every 526 was preceded by a WAC number, WAC, blah, 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 blah. Now we're seeing some changes. So we're left to speculate whether or not IPO is farming out some of their adjudication to other field offices. Maybe there are field offices that don't have the backlog that other field offices have. So I think that there are some changes internally that we're seeing. But beyond that, I'm not aware of any particular track that these things are put on. Did I answer the question? I think it did. I don't know.
Yeah, I think that covered it. All right. Let's get back to some of these other questions. What about, there's a lot of RFEs coming about based upon regional center loans. Um,
I mean the
I
partial
guess,
investment. Oh,
yeah,
that's
partial
Department.
investments and RC loans. Yeah,
Yeah.
in particular, RC loans. I understand a lot of RFEs are coming into play. What do you know about RC loans, I guess, and
Well, what
why
they're
they are?
worried about is that they're worried about guaranteed recoveries. They're worried about actual investments. They're worried about making sure that the money actually belongs to the investor. They're worried about making sure it's full $800,000. And when you make these loans a little close to home, right, when the RC is making the loan itself, then, it raises a question as to whether or not it's really the investor's money, and at the end of the day, what the investor's obligation is to the RC to pay it back. Um, on 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 partial investment cases like this, or cases where the RCs are making loans, my position is that if the investor can't get sued for the full amount of the money, and if they're not going to have to pay it somehow, way, shape, manner, or form, then it's no good. So there has to be, if you get an arrangement from an RC that doesn't scare you as an investor, then it's probably not good. It should frighten you because at the end of the day, you're obligated to pay somebody $800,000. And and that goes for partial investment cases too. I mean, you know, I'm not a great fan of partial investment cases for a couple of reasons. One of them is because it basically guarantees you're going to get an RFE. There's no way around it. You're going to get an RFE. And as a matter of fact, if you take a loan from an RC, you're going to get an RFE as well. Because they're going to ask you, they're going to ask you, did you pay it back? What were the terms and have you been meeting those terms? And so you're going to pay me, you pay me X thousands of dollars to put together an EB-5 petition for you. My objective is to get you approved. Secondary objective is to make sure that you're one of the 60% or 50% of the people who are currently not getting RFEs. Because when you get an RFE, you got to pay me more, or pay some other lawyer more, or pay me more to fix what some other lawyer did. So, people need to know that partial investment or RC loans, this kind of stuff, they're buying an RFE at a minimum. And, so there are other concerns, from an immigration standpoint and the issue of sustainment, of the investment that relate to this as well. Because, in the case of an RC loan that's good, if you're legally obligated on the day that the $800,000 is delivered to the project, then all right, maybe your sustainment period begins that day. But on a partial investment case, I don't believe that your sustainment period of 2 years begins until the $800,000 is actually engaged. So, these are other issues for people to think about. You want to get your money back. You want to get your conditional residence turned into a permanent residence. You want to move along in the process. And these are not good ways. I mean, if you have to do it, you have to do it. I don't know, my house is under contract. I need the money from the sale of my house. But I expected to close last week so I could make my EB-5 investment, but the I don't know, the buyer, they had a problem with their loan, and so I need to take, these are things that happen and you can't avoid it. But if you can avoid it at a cost that's not too serious to you, or I would do it. If the rate of return, if the interest rate that the RC is demanding of you is not significantly better than the interest rate that some other lender is willing to give you, then go with the other lender. Make it look like what we say, an arm's length transaction. It looks more credible that way.
And I get a technical question on this. So I get a question a lot because I see people saying like, well, some projects offer me a payment plan, right? And so my thought has always been, okay, I'll accept like a partial payment, but you got to know you're going to get an RFE. And in today's environment in a rural project, that could be as soon as 4 months from now. So the farthest out that I want to give you to make up your total payment is like 4 months because I want you to have the entire amount of money when your RFE comes. But I see
That's
other
right.
thing projects and other things where they instead make a different kind of thing where they say, okay, um, and they're legitimate loan terms, everything else, like, hey, we're going to loan you the money at 9%, and we're going to do this and that. But you have 12 monthly installments to pay us the money. So what would you do if you see that come in, but the RF, like you see the case come to you at 5 months, they've been making their payments, but they still have 7 months to go on payments.
I
Is
deny
that
it.
approvable to you? You deny
No,
that. Okay.
yeah, because it's not
Hmm.
approvable, right? It's not approvable. And there's no provision in, like if you apply for a visa and you come to the consular section and you're missing a document or some as part of your application is not complete, you can get a 221G. It's technically a denial, but what it is it says, go back and get me your birth certificate, the long form, not the short form, and they put it on hold. But I don't know of any procedure within the IPO that allows them to just put cases on hold. You get an RFE and it says, deliver this stuff to us in 90 days, show us that you're fully engaged, otherwise we're going to deny your application. And then that's what I think would happen. So, I probably would not be willing to sign up if the repayment period was longer than my anticipated adjudication period, to your point.
Mhm. So let's shift the subject a little bit here. A lot of investors have the fear of retrogression coming into play. There's a huge uptick in both from India as well as China, and in particular India. Let's talk a little bit about, the priority date versus when USCIS issues its visa bulletin.
Mm.
How exactly does the timeline work for an EB-5 investor? Let's say the priority date comes in, but the visa bulletin, like maybe walk us through how, you know, what is the risk at that stage and how does the USCIS evaluate? Is it on the priority date? Is it on the visa bulletin date? What happens if there's a gap between that? How exactly does that work?
Oh, you're
Well,
you're saying like the like what happens if retrogression occurs after you submitted your thing and you have a priority date, but you don't have approval yet?
Well, your priority date is, let's say, after the priority date of what was
let's
issued,
go.
but the
I think
bulletin has not come out. Yeah.
I can help here. Hang on, I can help
Okay,
here.
I gotcha.
Let's go to. I got a little sheet that I actually prepared,
Yep.
'cause I kind of sensed you were going to ask me this
I think
question.
I need to stop sharing, so I'll stop sharing, which allows you
See
to.
how I do it. So I share there, and I go here, and then I share. All right. Can you guys see? Can our visitors see? Our guests see this visa bulletin here?
I can see it.
I could see it.
All right.
Yeah.
So if you guys
Yep.
can see it, then I'm assuming that everybody else can see it. So this is what the mysterious visa bulletin looks like. So this is the January visa bulletin, right here. And if you look at the employment-based cases here, we go to the fifth unreserved, right? So this is just your basic, whatever. We see that retrogression has hit this pretty hard for our Chinese and Indian friends. So why would you ever, at this point, unless you got a lot of time to wait, you're not looking to file in this category. So you go down and you look at the rural set aside, the 20%, and you see that they're still current for Chinese and Indians, which is great. And then these are current. So what you're saying is today is the 5th of January. So theoretically, right? Theoretically, if I'm Indian, I could file and get a priority date of January 5th, 2026. And then when the February visa bulletin comes out, these dates, this C could retrogress to say September 2025. That they would put 09 Sep 25 in this box. What happens to me? That's your question, right?
Yeah.
That's my question. Yeah.
Yeah. Hasn't happened yet, but the understanding is that your expectations and rights with regard to concurrent filing are tied to the visa bulletin as it existed on the day that you filed. So if you filed today, that's current, and you can file. Now, you must file. Now, anybody who's in the United States and files the 526E and doesn't file the concurrent petition, the concurrent applications with it, are taking the risk. Because if you don't file them and then it retrogresses, then you're out of luck because you can't file your adjustment of status thing once February comes around and this retrogresses. So if you file while this is current, your place in the queue is held. Now, the bad news that you just got when this thing retrogressed, the bad news is that you now know that the adjudication queue that you're in is longer than you thought. But you're okay, because if you can get the I-131 advanced parole approved, you can travel. And if you can get the 765 approved, you got your AED and you can work. And you can wait it out. So I say here, right? Is the valid parole document an AED as good as a conditional green card? Yeah, kind of, but not as convenient because you got to keep renewing it. And it's certainly a little anxiety provoking because I'd rather have a green card than that, wouldn't you? I mean, but at the end of the day, that saves you. So, then there are other complications that are beyond the scope of my simple mind. And that is that if retrogression gets crazy enough, right? And, there's a queue that forms that carries over, but only for 2 years. Because at the end of the day, if you had enough of these categories encumbered by enough filings, it would actually refer back after 2 years into the unreserved category. But nobody really knows for sure that's the case because it's not happened yet. And USCIS, State Department itself, predicted months ago, around this time last year, that these categories were going to retrogress, that they were going to be not current. And it hasn't happened. They had a warning on the website, on the Visa Bulletin website. They took that warning off. And we've been carrying these, current things here, I guess, to the extent that USCIS is not worried about creating a queue, they're just going to let it ride. Maybe they have some sense of how long the queue is. Maybe they don't. There's no way to know.
Got it. Um, let's see here. Let's get to some. Does the USCIS retrogress dates based on pending 485 applications, which are filed with I-526E. Or, I mean, I mean, basically, let me reword this question for this investor. Um, does the USCIS, what are the factors for retrogression? Is it based upon the number of visas allocated, so the 485 approval, or it's not really necessarily how many 526E petitions, correct?
Yeah, well, let me tell a little story here because you're talking about two agencies now. You're talking about the Department of
Right.
State, which issues the visa bulletin and counts up the visas, and then you're talking about USCIS, and very often they don't talk to each other very much. And it's interesting enough that a little side note, there were instances where I was adjudicating immigration visas where there would be unavailability of visa, and I'd have a family of five in front of me. So, there were only three visas available. So what we did, believe it or not, there's some flexibility there. You send an email to the visa office at Consular Affairs in Washington, D.C., and you say, "Hey, I got a family of five. I can't just approve three of them and leave two of them here in Colombia or whatever." And then, even though I don't know where they get the legal authority to do it, but they actually physically release in the system, in the computer system, two visas, so that when you press the button, those two people can actually get their visas. So the reason I tell it, I explain that is that state controls the actual issue of the visas. Now, when we talk about issuing visas, we're also talking about slots for adjustment of status. So when you say, "Well, I'm not getting a visa, I'm adjusting my status," so that's a visa. So visa means place in the immigration queue. That's a visa. So so the health and welfare of your 485 depends on what the visa bulletin says. But we don't know whether or not what the visa bulletin says reflects the actual real-time receipts of 526Es that USCIS has. So entities like the aforementioned IIUSA, and then there's another, the investor organization that's running around. I forget what the name of that is. And certain lawyers are trying very hard, filing, Freedom of Information Act requests and trying to get this data. And, for the investors who are listening, we know, the five of us know, but there's lots of bright lights, out there who are trying to read the tea leaves and figure out, really what's going on here so we can make predictions about this, and we just don't know. But the bottom line is, if you file now, do your concurrent filing, and you'll be safe. That's all we know.
Got
You
it.
should be safe.
Um, Very good. Still a couple more questions here
But that
from
that is a real nitty gritty, like in the weeds kind of thing for our folks to be listening to this evening, But you know,
Well, we got a lot of engineers on the call. People like to get in the
a
weeds
lot of
nowadays.
specific questions. We got some lot of
Yeah.
specific questions, some which I'm answering here for us. But let me go uh, through here. Um, let's see. Um, lot of I know a lot of these answers, but I'm going to ask you these, Steve, so the whole group can hear that. Because I don't know if I type the answer, if everyone gets to see it or not. But let's talk a little bit about the CPSA and like the age, of the dependents and how they're getting frozen. Age of dependents are frozen upon what, 526 adjudication, or is it, if the 485 is pending and they're filing concurrently, they're still frozen age? Can you talk about a little bit about that, please?
yeah. So we never really, first let me talk about it from the adjudicator, USCIS adjudicator standpoint. We never really cared about it. We never really thought about it. So you know, there were situations. Now that I look back on it, I think about our poor Chinese clients, and I think, there were probably cases of files where I could have done some Chinese family a solid by just pushing their file back into the file room and not looking at it. Because while that 526C is pending, the children are not aging. So they stay the same age. And then the minute the thing is approved, then they begin to age. So, you know, but from the IPO adjudication perspective, it wasn't an issue. From the State Department consular officer perspective, it was an issue. So we're not just talking about EB-5 cases now, we're talking about other, immigration categories, that rely on this. But whenever somebody was close, there was always a calculation that would be done on every file, physical file that we adjudicated. And you'll also see that sometimes the post, right, the consulate or the embassy will actually refuse to give a visa interview to somebody who they think is aged out. Now, it can also happen at NVC. So if NVC feels that the person has aged out, they won't refer that person's file to post. So, but this is really an NVC and State Department issue, not a USCIS issue. I do think that maybe there is some attempt on USCIS's part to give the Chinese a break and, to delay some key Chinese applications in order not to hurt people. But I'm not so sure, and I never did it, and I never saw it happen. Not because I didn't want to help people, but just because it never came up, really. We never articulated that.
Got it. Okay. We're past the time here. I still have some.
Yeah, but we're
more
having so much
questions.
fun, I mean.
Well, I appreciate you definitely staying past time, and maybe we'll go through just a couple more questions if that's all right for a few minutes, and then we can wrap it up
I
here.
got one for the
Um,
end, just for people that want to hang out afterwards, but a little
yeah,
less
our attendee
pointed.
list
So
is still quite large. Everyone's still focused, and the
Yeah,
numbers are
they're
good.
all hanging around because they're saying, we have no idea what this guy's talking about. Maybe if we stay on long enough, he'll make some sense.
there you go.
Hopefully that's not the case, but, you know.
Go for it, Kevin. You got one?
Oh yeah, no, I mean, if you got any pointed ones, I just kind of wanted to end
Yeah.
with like, because you could ramble on with this forever, but one thing that I go to a lot of these webinars and every event and everything, and everyone always talks about source of funds and retrogression and all the immediate things. And I know that everyone on this phone call is the perfect angel, but there are people out there that have made mistakes, right? And one thing that nobody ever talks about in any of these seminars is what if you're one of those people and you have made a mistake in your past? Maybe you made a white collar crime, maybe you did a violent crime, maybe you did a drug related thing, maybe you did something, completely different. But, like what, like kind of, you know, what's the mechanism for those folks? And I mean, like, is it they just try not to, I'm assuming they're gonna like, submit some kind of criminal record along with their I-526 or something. But are there certain crimes that are like you got no chance, so don't even try this? Are there other ones where, I'm just
Yeah,
curious as to what people think. Yeah.
like every other question that you've asked, I'm going to take a simple question and make it more complicated, okay? So, let's talk about the process. As an adjudicator and then ultimately a consular officer sees these things, what's the assessment of these particular crimes or particular offenses, right? So when you file your I-526, first of all, first thing I would do is talk about it with your attorney. You got to talk about it ahead of time because you don't want to go through all this effort and all this work to find out that you're never going to get approved. Right. Now, most people who have a visa and who've received that visa recently, if they've been honest on their DS-160 or the DS-260, the forms you fill out to get the visa, if you've been honest on those forms and you've revealed these things and you receive the visa anyway, most of those people are going to be okay. And they don't have to worry because they say, well, I got a visa yesterday, tourist visa yesterday. And I told the truth. So fine. So, all right, great. So they, in confidence that they're going to be approvable, they fill out their I-526, they file it. A couple of months later, it ends up on my desk. I'm an adjudicator. So does the adjudicator do a security background check? Limited, yes, they do. The Consular Consolidated Database is the big Megillah with all the data that everybody wants. Every intelligence service in the world wants it. Every agency in the US government wants it, and the State Department doesn't want to give it up. So they have limited access to it. And so they do this. But at the first instance, the review that the adjudicator, the 526E adjudicator does, is really not for the admissibility issues. It's for eligibility. And under the law, there should be two differences between that. I can be eligible as an entrepreneur, as an alien entrepreneur, get an approved 526 and be a murderer, theoretically. If the murder that I did doesn't have anything to do with my source of funds or the project, right? So theoretically, the first review that the adjudicators do is not to determine whether or not I'm a murderer, but to determine whether or not I've got some financial crime or some crime in my past, a fraud conviction, that'll affect my credibility and the lawfulness of the source of funds. Am I a narco? Right? If I'm a narco, theoretically they could still approve me, but they got to make sure that the money that I'm using came from my legitimate businesses. So, but the reality of the situation is if the bells and whistles go off, the adjudicator is going to have a problem with it. They may send it out. Sometimes cases get bogged down because they get sent to the National Security Review or they get sent to the Fraud Directorate. And once they leave the adjudicator's desk, the adjudicator has no control over it. It goes out to a committee. They know, God knows when you're going to hear about it again. That's when you come and you want to file a mandamus. Anyway, so let's say you get through all that. It goes to the consular officer. Then comes the issue of determining whether or not it's a crime of moral turpitude and something that will create a hard, what we called in the trade, a hard ineligibility. So, for example, fraud. They're very, every crime is different. You've got to look at the crime you committed in the jurisdiction in which you committed it. What did you admit to? What is the analog under the U.S. system? Does it offend, our sense of righteousness or whatever? Is it a crime of moral turpitude? Pedophilia. These are hard no's. These are hard stops. And it's a pretty sophisticated analysis, frankly, in some cases. I had one recently where the guy. He wants desperately to file an EB-5 petition. He's not Indian, so he doesn't, or Chinese, so he doesn't have to worry about retrogression, really. He's got time. And he did the right thing. He paid me a flat fee up front to analyze his case and to give him an opinion on whether or not he would be approvable. He spent 5 years in prison for vehicular homicide. And my end opinion to him was that his vehicular homicide was based totally on negligence, not on intent, and therefore would not be a crime of moral turpitude. I mean, there's more to it than that, but that was ultimately the determination that I came up with. And so he's going to get his stuff straightened out because he's afraid. He's got businesses in the United States, he's got property in the United States, and he doesn't want to be found ineligible to visit the United States before he squares up, all of his effects. Then he'll go back, tell the truth, and we'll see what happens. But anyway, so that's the process. That's the read through. So, my advice to people is just talk to the lawyer ahead of time. And if you have a regional center or a project or a lawyer that is pushing you, hey, don't worry about it. It's all going to be great. Be wary. Recognize that this is a very competitive environment that we work in, and that not everybody's like you guys, like our hosts, and not every lawyer is like me. And there are people out there who will tell you exactly what you want to hear, and they will push you in ways that are not good for you. And ultimately, a legitimate regional center, a legitimate project won't accept sketchy, poorly thought out source of funds presentations and will not accept investors that are not qualified because it doesn't do anybody any good.
Absolutely.
I think we're wrapping it
And
up, right? So I would like to say just one more thing before I leave everybody all anxious and nervous, right? And that is this source of funds thing it's so big, it's so, everybody worries about it so much. But, I would say to people, don't worry so much. First of all, use the people around you that know what they're doing and that are capable, competent, and care about you, number one. Number two, don't move money without talking to the people who are going to have to write up the source of funds report first, because you can make it even more difficult. And three, I don't know, maybe it's just, the irrepressible optimist that I am, but if I believe in you and you're not a criminal, I don't believe we can fail. There has to be a way to make you successful. And if you're legit, we'll find it. And to this point, I haven't had in my experience working with USCIS now and against it, whatever, for a couple of years, I haven't had a situation where that optimism that I have has been frustrated. And the biggest problem I see is just bad work that I end up having to fix. So find the right people, get it done right the first time. Don't spend another $8,000 on an RFE and create all that anxiety for yourself.
That's kind of what we say as well. We're, from the regional center perspective or the NCE at AIC Group, um, you know, don't, choose an experienced EB-5 attorney. The source of funds are so critical. Taking shortcuts out there can only hurt in the long run, and you end up paying way more. It's, even from our perspective, not only from the EB-5 investor perspective, you don't want to have to deal with an RFE. It ends up costing more. From our perspective, we take pride on not having any 526E, denials and everyone always getting approved in our projects, but we also ensure that the attorneys being used are well experienced ones that who have, not just some random cousin or a friend who's an attorney who's doing their first EB-5 petition, right? It really needs, I know you can save money on that, but it is really critical to get an experienced EB-5 attorney because really fundamentally, if you don't have a criminal background, which is very far and few between, it's truly your I-526C approval is going to be based upon, I mean, if the project's I-956F approved, it's really going to be your source of funds and whether, the path of it, the legitimacy of it, where it
Yep.
all came about. So, yeah.
Hey, listen, one of the reasons I like doing this work is because it calls into question every single thing I've ever touched in my life as an attorney. And there's a lot of stuff I've done as an attorney that we haven't talked about. Securities issues, it's there. Real estate, you bet. Divorce, yep. Pension benefits, yep. I mean, you name it, it's come up in a source of funds setting. So fine, there are a lot of really good attorneys out there, immigration attorneys, but they don't have that kind of commercial background. And, so your statement is 100% correct. There are definitely people who will do it cheaper, for example, than me. Guarantee you can find people who do it cheaper than I. But knock yourself out. Go ahead.
No, well, very good. I didn't get to everybody's question here, but we are 30 minutes technically over. I do appreciate everyone's attendance today. On the screen here, if you have any additional questions, happy to address those one-on-one. Also, Steve is available. He does offer a consulting service. He can be reached at steve@pazanconsulting.com. So steve@pazanconsulting.com. And myself, Vikram at AIICEB5.com or WhatsApp. Most of you who are on the main WhatsApp channel probably have my number and as I'm quite active on there, but please feel free to reach out with any additional questions. And with that, we'll conclude today's seminar. And once again, Steve, I really appreciate you taking out, late in the evening and speaking to all of us and giving your insight both from, as an attorney, as a USCIS officer, and having so much experience both inside and out on all sides from the EB-5 perspective. So really appreciate your time this evening.
It was an absolute pleasure. I wish everybody who's listening a lot of luck in whatever they decide to do. So, and thank you.
Thank you,
With
Steve.
that, we'll sign off. Thank you.
Signing off.
All right.